Good morning. I'm Tom Schmidt again from the Florida Injury Law Firm. This is the third in a very short series of discussions we're having about the law in Florida when it comes to personal injury cases. We've talked about the fact that we have to prove there's a duty to you. We've talked about the fact that we have to prove there's a breach of that duty. The two other elements that we have to prove in Florida are causation and damages, and I'm going to talk to you about those together in this brief segment. If a defendant wrongs you by violating a standard of care or not using reasonable care, they've breached a duty to you. But that doesn't mean that you have a case. Your case is dependent upon whether the breach of the duty caused damages. And this is largely where defense insurance companies focus when it comes to defending, especially automobile accident cases. Almost always the issue is, did the damages, or were the damages caused by this injury? And it's a very complicated thing for us to prove, especially when it comes to herniated disc cases, spine cases, that kind of thing, where there's always an element of some pre-existing condition because the person's older than 30 years old, etc. So that causation of damages becomes extremely important. The other element of that, of course, is the damages. You might have a great breach of a duty case and you might have some damages, but if they're not significant damages, it's not a significant case. So we're trying to prove causation and damages, and like I say, this can be very complicated. These are issues that need to be analyzed by lawyers who have a lot of experience in this area. We have a tremendous amount of experience here at the Personal Injury Law Firm evaluating causation and the amount of damages. If you have a personal injury case and you were damaged due to somebody else's negligence, call us. I'm Tom Schmidt from the Florida Injury Law Firm, 407-566-2210.